5 seconds to go. Start. Therefore, we are of the considered view that section 11A, though applicable to the cases of acquisition initiated under section 17(1) of Act, 1894, the consequence of it will not affect the case where the land has absolutely vested on compliance of subsection 3A to section 17 of Act, 1894, and 80% of estimated compensation is tendered and paid. Stop. Hence, when there is a challenge by the land loser, each case will have to be considered on its own merits to determine whether the prerequisite condition to tender and pay as contemplated under subsection 3A is made before possession is taken. Stop. If in the case concerned the mandatory prerequisite is not complied, such acquisition will lose its character as being under section 17, and if the award is not passed within 2 years from the date of the declaration, it will lapse and not otherwise. Stop. The benefit of said provision is available only to be invoked by the land loser and cannot be invoked by the acquiring authority to claim lapse by pointing to non-compliance, since the vice of non-compliance cannot be permitted to be converted into a virtue. Stop. Para. Though the learned counsel for the beneficiary respondent number 2 placed reliance on the decision in Indore Development Authority versus Manohar Lal and others 2028 SCC 129 rendered by the Constitution Bench to contend that it has been held therein that paid as contained in section 24(2) of RFCTLARR Act, 2013 does not include deposit of compensation in court, we are of the considered opinion that the same will not be applicable to the question under consideration before us in this case. Stop. In the instant case, the requirement to tender and pay 80% of the estimated compensation and the consequent lapsing as considered above is in the context of exercise of urgency provision, which permits a deviation from the normal process of acquisition, and the payment envisaged is to take benefit of the said provision. Stop. In contradistinction, the consideration in the cited case is about the effect of section 24(2) of Act, 2013 in the circumstance contemplated therein. Stop. Para. In considering the effect of Satyendra Prasad Jain Supra, it would be appropriate to take note of the decision relied on by the learned senior counsel for the appellant in prevailing process is applied in determining the compensation. Stop. Further, though after being nudged by the High Court, the award in any event was passed on 9th June 2008 under the old regime, which is now to be substituted with adequate compensation. Stop. Para. On weighing all aspects of the matter, we deem it appropriate that it will serve the ends of justice to direct the respondents to determine the market value insofar as the appellant's land is concerned by reckoning the relevant date as 9th June 2008 bracket start, that is the date on which the award was ultimately passed bracket close, by applying the yardstick under Act, 1894. Stop.